Good afternoon, everybody. This is Irene Weisman. Today's Wednesday, January 22nd, 2025. Okay, so today we're going to continue to talk about the changes that are currently happening in our U.S. immigration law. So between yesterday and today, it's about 1 o'clock in the afternoon. So I don't know, maybe later in the day there's going to be more changes, but between yesterday and actually probably between Monday and today. So I already told you about most of the executive orders. A couple of more came out. So let's go back to one of the ones that I previously discussed, the birthright citizenship executive order. So there have also already been numerous lawsuits filed against that. The lawsuits were filed not only by the states, I believe about 14 states filed lawsuits, but also numerous immigrant rights organizations have already filed lawsuits challenging that particular executive order. Other lawsuits were filed as well, challenging some of the other executive orders, but I think this is, the big one, and I have a good feeling that we're going to succeed on this one. Just you can't override a constitutional amendment with an executive order. Anyways, going next, the Lake and Riley Act. So that has passed the Senate, and it is going back to the House. Once we have the full version of the law, I will talk about it more to, basically to give details, but for the most part, if you have been arrested or convicted of any theft-related crimes, you're going to, basically it says that the state has to give you over to ICE, and you're going to be detained, mandatory detention for the duration of, your immigration court hearing. Okay, so basically mandatory detention for theft-related crimes for undocumented people. Okay, it also gives states more rights to sue the federal government for, for enforcement-related things. Okay. Next, and this is a big one. This is the one that I really wanted to talk about. Another I'm not sure if this is an executive order or not. This is more of a directive that came out from the acting director of DHS. So we don't have a director yet because she's going through the process of confirmation that's going on in Congress, but this came from the acting director of USCIS, and basically it's an expansion of expedited removal. And what it says is that if this doesn't limit apprehensions to 100 miles within, close to the border, this is everywhere in the United States. If you get stopped by ICE, if ICE checks your documents and it is determined that you do not have status, you're fully undocumented and nothing is pending, in immigration court, no protections have been filed, they can remove you without without due process, basically without issuing a notice to appear and having you go through the courts. Okay, so this is a very big expansion of expedited removal order and what it does. So my advice to you would be, if you do have paperwork that is pending with USCIS, especially if you are By the way, this has to do with people, with recent entrants, okay? And for people that, that came through the border. But anyways, if you have an application pending with USCIS when you submitted it, okay, or wherever, maybe it's pending in immigration court, but when an application was submitted, you should have a receipt notice, okay? I would have a copy of that receipt notice in your phone. Take a photo of it, take a photo of, important documents, and store it. Like, create a folder in your phone, title it important immigration documents, or just important, however you want to title it, and store it there, that, God forbid you get stopped or something, you can just open your phone, you can show your documents, you can show that you have things that are being processed, documents pending, because they're saying that the burden is going to be on the undocumented person to show that in fact they have the right to be here, they have applications pending, and you can quickly do that if you can, you shouldn't be carrying all those documents with you, but if you have, photocopies of those documents in your phone and you can quickly access them, I think it would be helpful, okay? Another thing that they did was basically there was a limit as to where ICE could go and detain people. And previously we had limitations on ICE going near schools, churches, hospitals. Okay, now they're saying ICE can go anywhere they want to go. Okay, so the so-called sensitive areas, so they have eliminated the so-called sensitive areas, and ICE can go in those, to those areas and stop and check documents and arrest if they deem that necessary, okay? So those are the big changes that have happened thus far, going further from what I have discussed on Monday. These are big ones. If you don't have an application pending, if nothing is pending, maybe it's time for you to schedule a consultation with an immigration attorney to see, maybe you have overlooked something, maybe something can be done, just in case, okay? And go from there. Look, we can't help everybody, okay? Not everybody has an immediate relief, right? Or something that can be done to help with their immigration status. But sometimes you have something available and you don't even know about it, okay? I mean, this happens all the time. People come to me for a consultation with one issue, and I start asking them questions. I start conducting a consultation, and it's like, well, okay, what you came with, that's not going to work. However, you have this, this, and this, and we can certainly try doing this. The law allows it. We can do this. Up to you. Want to proceed? We can do it. So sometimes you just don't know, okay? That's why, one of the reasons why a good thorough consultation is required, okay? So hopefully this was helpful. I will see everybody soon, and have a great day, everyone. Bye. Still Irene Weisman over here. I just want to, I finished, but I think this needs a little bit of clarification. The expansion of expedited removal. So this has to do for people that are present in the United States without being inspected or paroled, okay? So it's, basically entry through the border, and if you haven't been inspected or paroled, and this happened within the last 2 years, okay? So, if you came in with a visa and overstayed, it's not going to apply to you, okay? This is just present without inspection or parole. You have to show, that this, yeah, and 2 years, okay? So just definitely expansion of expedited removal. This now throughout the country. You have to you have the burden to show that your entry was more than 2 years ago, and if it was within 2 years, the burden is on you to show that you have an application pending, whether it's in USCIS or immigration court. Okay, so hopefully this clarifies it for you.